Matter is pending before the High Court now.
No, Lord, I'll tell your Lordship what's happened. See, the finding the High Court is done. It's actually, I must tell your Lordship, we went to the Magistrates Court because the rules at that time were 69A.
Does not have the power.
My Lord, I'll show your Lordship why. Show your Lordship why. The term used is competent court.
The competent court with the Tripura High Court judgment, the competent court must otherwise inherit the power.
My Lord, I'll tell your Lordship why. Because 69A, which is, just see the original rule.
Please understand, 69A does not cover defamation.
My Lord, just, I know, but please see not what this
Now,
is.
since 69A did not cover defamation, the 2021 rules cover defamation and provide for the framework, Rule 5 and Rule 10.
Yes, my Lord.
So in this situation, if the magistrate lacks inherent power, it would be the civil court. Just Mr. Luthra, examine it independent of electronic record.
Yes.
If documentary defamatory article was published in a newspaper, you had a right to file a complaint.
Yes.
Could you get an injunction from further circulation?
My Lord, that's the point I seek to make.
Further circulation
Lord, that's the point. Lord,
and that's what.
Lord,
You go to the civil court, it would be better. You go to immediately get that order.
May I just say this? There's a slightly distinct issue, not I'll just point out. But what happened was, once we went to the magistrate court, there are two orders. One is
first order is to take down. Second order is for notice for non-compliance.
Not that's late. That happened. Thereafter, not the matter goes to the revisional court.
In the
revisional court, not the revisional court, without hearing me, this happened. Just see that for a moment.
So what? Order without jurisdiction.
But revisional court did not hear me. Not
a patent lack of jurisdiction, according to us. Inherent power not there in the magistrate. Can't exercise an order of takedown, sir. Yeah. You know it better. What will be?
My Lord, may I just show your Lordship the 2009 rule for a moment?
Why are you flagging a dead horse?
Can I attempt to show you the 2009 rule, Lord, and I'll leave it at that, Lord? Just see the rule for a moment. Not that rule, your Lordship.
NSS had the wonderful opportunity of putting the magistrate on par with the district judge or the civil judge junior division. Did not do it. What will we do?
Lord, may I just show you those two rules? And I understand what is falling from your Lordship, but let me just show you the two rules, Lord, for a moment. At page number 75, Lord. The rules begin. That's the 2009 rules. I understand what is falling from your Lordship, but just let's have a look at that. Rule 5. The designated... 69A. The court is saying defamation is not covered. Listen to what the court is saying. Yeah, correct. Right. May I attempt to not show that to your Lordship?
Yes.
The designated officer may, on receipt of any request from the nodal officer of an organization or a competent court, or by order, direct any agency of the government or intermediary to block for access by the public any information or part thereof transmitted, received, stored, or hosted in any computers for any of the reasons specified under 1 of 69A. Now, please look at 10, man. In case of an order from a competent court in India for blocking any information or part thereof generated, transmitted, received, stored, or hosted in the computer.
New court can also do it.
Well, I'm saying it has to be a court.
A Tehsildar.
No.
The rule does not define competent court.
It will have to be a court in terms of not...
In terms of what? Rule does not define. I examined it. It's not there. Competent court not defined.
Not only does the rule not define, we'll have to go back. In fact,
by common law and the statute which creates that court.
May I just tell your Lordship why perhaps, if I may just point out why we may have to go back, Lord? Just see, Lord, you'll have to go back to the definition in General Clause Act, Lord. There I would submit, Lord, the court may be...
It includes a revenue court. Even General Clause is there. Mr. Look, the best is you go to the civil court, get that injunction. Then you have a good case. You have a good
May I
case.
just say this, but I'll go back to the session, not go back to the. May I just show your lordship one more document and I'll leave it to your lordship. Just see not page 178 for a moment. Just see 178.
178.
178. But even the police has written to them. Now the problem is while they've disabled the links here, the links are available overseas. That problem still remains not so people can root it and see it. So that's the challenge. Not please see your lordship put to me, Lord. I'll go back to that quote, but just see exhibit A, D, Lord, at 178. This is part of the just see this. My learned friend on the other side is there. Not they have to take them off. Not exhibit D is very clear. 25 November 2021.
We removed it. We removed it. Are you saying it's available out of there?
There has to be compliance, not the court. This has to be complied with.
We have complied, if I may say, I'm on caveat, my lord, with respect. Within 36 hours of the order being passed by the magistrate, even though it was without jurisdiction, we have removed all the links which we could within India, and they've admitted this in their synopsis at page 8.
We are already asking.
Sorry?
My lord, we have removed the links within 36 hours of the order being passed by the magistrate, even though it is without jurisdiction. He has admitted this fact in his synopsis at page 8. 4 out of 5 links are removed. The solitary link that remains to be removed is a foreign link.
Thank you very much. Thank you. Why you allow interruption like this?
Not it's still available, not today. We got it on the pen drive. It's available. Not yesterday. My friends said they got it checked. Not it may be disabled here, but it's available in the UK. Not so you can access it through any UK server. Not it's still there. He's got it on the pen drive. That's not correct. My learned friend will have to verify that.
You have a remedy in law. You avail that remedy. We have heard lunch in the council for the question. We see no reason to interfere with the implemented passed by the High Court. However, it will not preclude the petition to approve the civil court.
Not may just say the observations of the High Court would otherwise stand in my way.
No, it goes without saying that in the event the petitioner avail the prescribed remedy, the observation made by the High Court shall have no bearing in adjudication of such dispute in accordance with law, or on merits and in accordance with law.
Grateful, deeply.